This is Kip from Malek. Today I'm going to be talking about a case called Weaver versus Eaton. And this case came up because, like most of these situations, these are cases or kind of mirror some of the facts of the cases that my clients have. So the Weaver versus Eaton case, it involves this going and coming rule, and it's almost a subset of the going and coming rule, and I'd call it the relocating employee rule, or maybe you're in town for a convention rule, and you'll see why I say that in a second. But the going coming rule, and I've done other videos about that, but it basically comes into play when the injury doesn't happen at the job site. So the common situation is you're driving from your house to your work, and the going and coming rule basically says going from portal to portal. Essentially, if you get injured in that capacity, you're not on the road and you're driving just to your work site. It's not a workers' comp claim, and the idea is the employer shouldn't be responsible for the employee, for all the injuries and risks that they may face in that scenario. So, and that's a decision that the state of Ohio has made. So, but there is exceptions to going and coming rule, and again, I call this the relocation and relocating employee rule, or in town for a convention rule. And so in Weaver versus Eaton, it's a death benefit claim. So the injured worker in fact died, and so his wife is filing for her own claim, a death benefit claim. But in order to have a death benefit claim, the injured worker, or the decedent rather, has to have been able to participate in the workers' comp claim. So, and the unfortunate facts in this situation are this guy was working for this employer. He lived in North Carolina, and he was relocating to his employer's plant in Brook Park, Ohio. And he was staying at a hotel in Brook Park, and apparently, carbon monoxide from the boiler room used to heat the swimming pool leaked carbon monoxide in his hotel room, and then the guy ended up dying, which is kind of insane. And so, when the employer's fighting it, because they're like, well, why is that our responsibility to happen at the hotel? It didn't happen at the job site. And I think they won at the trial level, and then the employer appealed, and then you get this Weaver versus Eaton, or Eaton versus Weaver case. And so the court analyzes the facts, and essentially in all these going and coming cases, you're going to look at two things. You're going to look at whether the injury arose out of the employment. They say arose out of. That just means something, and in the course of. So you have to have arose out of the employment activities, or arose out of work, and then in the course of employment. So arose out of, they have a way that they phrase it. They say consistent with the contract for hire, et cetera, et cetera. I don't know. The way I look at it is like you're kind of doing something in furtherance of your job. So, like, I don't know, if you're at your home playing video games and you're a nurse, obviously that would have zero applicability to it wouldn't arise out of your employment, because or in the course of, rather, because it has nothing to do with your job as a nurse. So it has to be kind of consistent. And then the arose out of, they look at this, there's this case called Lord v. Darty, and they have these three factors. I call it PCB, but it's proximity, control, and benefit. So proximity to the job site, control the employer has over where the injury happened, and then the benefit to the employer of the person being at that particular place when they got injured. So it has to arise out of employment, and then they look at these three factors of in the course of employment. So in this one, they're saying it was in the course of, because essentially this guy had to relocate and to this new place, and that benefited, or that was consistent with the contract for hire, because they needed him to relocate to this location so he could work at this plant. And so that's why he was in Brook Park, and that's why he was in the hotel or motel. And then arose out of, they kind of look at it, I think they actually kind of, the control, obviously the employer has zero control over the boiler room of a hotel unless you're working for the hotel, but that's not the case in this instance. So control, there's really no facts that helps in that situation. But benefit, obviously, is a benefit that benefits them to have him there, because he could start, I think he's looking for houses or whatever, but he could start working at that plant right away. And then proximity, I actually think the hotel was actually fairly close to where he was actually working at this plant for this job. So whenever you're going through these appeal cases, they're referring to other cases called precedent. So the courts look to these other cases to determine whether another court or a higher court kind of ruled how they looked at a similar fact pattern. So they looked at this Boer versus Industrial Commission case, and this happened way back in 1947, but it's a Supreme Court case. I don't think it's been overturned, and so it's still good law. But essentially, this lady was I think it was in Toledo, or it was either Toledo or Akron, and part of some convention, and she was en route to the hotel where she was to stay during the Teachers Institute, and then she got in a motor vehicle accident. And so they looked at that, and they said, hey, pursuant to this kind of analysis, the sole reason she was in town was to attend this institute to learn whatever she's going to learn, and then take back that to her school or the university where she worked at. And it didn't matter that it happened, that she was, and I think she was taking a detour, but the court said it didn't matter if if she had to eat somewhere, she had to sleep somewhere during her stay, and no such accommodation was being provided by her employer. And to say that she might have had her dinner and have slept elsewhere would be no answer, no defense. For one can say what might have been fallen in such event. So the employer was saying, hey, she chose to stay at this hotel, therefore that was her choice. Why should we be responsible? And the court's like, no, the reason why she was there and the reason why she was driving there was because of this convention or whatever. So that's why I call this the in town for like a convention type of rule too, this case anyways. But the other thing that is unique about this, and which I think I kind of glommed onto this for my case, is they make it that point and they pull this out of, I don't know if it was that, I think it was that case or some other case, but they say we are aware of the different situation that would have been presented had Apelli been injured in her home city while going from her home to the school where she taught, a fixed place of abode and a fixed size of employment situation, such as was before the courts in this other case that they're referencing. So basically they're saying if this person was in her own hometown and she was going to this convention or she was going to a restaurant or something, they would probably say, yeah, different situation, she's in her home city, we're not going to be as lenient, or we're not going to give as much room for this to be a workers' comp claim. So that's why I call these like out of town relocation employee kind of rules in this case, because this guy, he's out of town, this lady was out of town, and then they have another case which they refer to, which is kind of instructive, similar along the same lines of the guy who died in the hotel from the monoxide poisoning, but it's Burkett versus Mayfield. And this guy, he relocated as well, and he was in town, whatever town he was in Ohio, and he was looking for a home to live in permanently. And while he was driving to home shopping or looking for new houses, he ended up getting in a motor vehicle accident. And the court, in that situation, they basically said it was consistent with the contract for hire. So again, it was in the course of employment, and it was and it was a benefit to the employer for this person to be looking for houses because they're going to be working in this town. They relocated her from wherever he was working before, and they're having him work here, and therefore, again, benefit to the employer. And the other thing is that the other fact that was kind of helpful for this particular person is the employer was giving, I think they subsidized the guy's car that he was driving around, or they provide him a car. So if the anytime employers provide you some kind of benefit, some per diem, something like that, that's always helpful in making a connection between whatever you're doing and your work, so making a workers' comp claim. But be that as it may, this kind of subset of the going and coming rule, this was relevant to a case I had, and it was helpful to have this. And so that's why all these cases, that's why you get workers' comp attorneys involved, because you may not be aware of all these little cases that are carving out and defining your situation, but your workers' comp attorney is going to find that case and they're going to be able to use it to help you. So be that as it may, if you have a question, concern about anything I discussed in this video, leave something in the comments. You could call our office, you could email me, and as always, I would strongly recommend you get an attorney. Either reach out to us, get us involved, at least run it by, your situation by us, or look in Google, find another attorney. I'd direct you to the Columbus Bar Association for referral, but apparently they're not advertising that anymore. So I'm going to direct you to the Ohio State Bar Association referral program, and I'll put a link as well. So you could go ask us, you could go look for an attorney there, but if you do have a work injury situation, get somebody involved, run your situation by them. Don't do this on your own. All right, thanks for watching. This has been Kip from Malek and Malek.